Thank you, Mr. President. I know that we have been primarily discussing our state's budget this week, but I felt like it was really important for us to talk about something that has a national impact that took place in our Supreme Court. On April 29th, 2026, the United States Supreme Court issued a decision to allow states to systemically dilute minority voting power. The decision effectively gutted the remaining protections of the Voting Rights Act, which is a landmark civil rights law that restricted racial discrimination in voting. The decision makes it nearly impossible to challenge a redistricting map on the basis of race. Let's be very clear. The Voting Rights Act effectively ended Jim Crow at the ballot box. It was created because Black and brown Americans were legally shut out of the democratic process through things like literacy tests, in which Black voters were given impossibly difficult questions to answer or asked to recite sections of the Constitution by memory, or poll taxes, in which states required Black voters to pay a fee to vote, or property requirements. This doesn't include other means of voter intimidation, such as threats to job loss, evictions, arson, and even murder. But because of the Voting Rights Act of 1965, each of those barriers were deemed unconstitutional. Now, here in Michigan, we like to tell ourselves a comforting story about voting rights because we're a northern state. We're not Alabama or Louisiana or Mississippi. We somehow escaped the long shadow of voter suppression, but history tells us otherwise. Lansing sits at the heart of Michigan's democracy. It is here where laws are written, elections are administered, and constitutional promises are meant to become reality. But even here, and cities across the entire state, equal political power has not always been granted. For decades, Black residents could technically vote, yet our voices were often muted by how power was constructed. District boundaries fractured neighborhoods, at-large and block voting systems diluted representation, voting strength stretched thin. Representation failed to reflect the cities that exist today. This wasn't a loud disenfranchisement that we often associate with the Deep South. It was quieter, more procedural, more bureaucratic. And because it was subtle, it was often ignored. The Voting Rights Act isn't a dusty document on a shelf. It created a pathway for Black and brown Americans to finally have a voice in our democracy, and a path for us to vote for diverse representation at the local, state, and federal level. Is it wrong for me to want to elect representation that looks like me? For me to want to elect people who share my lived experience? Let's be clear, when we are denied a seat at the table, when communities are denied meaningful political power, schools go underfunded, infrastructure is neglected, public safety and health decisions ignored live realities for marginalized communities. Under the Voting Rights Act, as it was long understood, communities could challenge those outcomes. Courts could ask whether the rules, however neutral on paper, produced inequalities in practice. This week, the United States Supreme Court has now narrowed that path. In her dissent, Justice Kagan closed with a warning about the national impact of the ruling. She said the consequences are likely to be far-reaching and grave. The question now becomes, when those consequences reach our state, how, colleagues, will we respond? Thank you, Mr. President.